So like that is for this topic, judicial review of executive power or executive power and its limits. Um, it is important. Let me just share screen, guys. Just a bit confused here for a second. Share screen and there and share. So that's the key question in the whole topic, really, I would say. Can you identify whether the courts have the power to interfere with the exercise by government of its executive power, executive functions? And if they have, and of course the second part of the question is the more interesting and important part, under what circumstances? I mean, you guys all know already that the answer to the first part of the question is yes, right? So, like, you know, for the exam, and what you need to think about is the second part of the question. Under what circumstances and in what kinds of contexts? And I suppose as we'll get, and this, by the way, this topic gets much more technical, and you'll see that now, even already today, you'll probably see it. Do you know, like there's different thresholds. So that's a new phrase, I think. I don't think I've used that phrase yet in the module. Thresholds. There are different thresholds for intervention by judges in executive power in different contexts. So in this context, the threshold might be really high. And in that context, the threshold might not be so high. And you have to understand why it would be really high in this context and why it would not be so high in that context. What's the difference? And what does that have to do, or how is it related to the text of the Irish Constitution and the institutional structure that the Constitution envisages? Right? So this is what I would say is big boy and girl constitutional law. Like, this isn't McGee and the Attorney General and kind of simple stuff that we can all relate to. This is now getting more technical. And I suppose the other point I was just making before I hit record there was, under the Irish Constitution, in the plain text, it is crystal clear that the legislature, the Oireachtas, does not have the authority to enact laws that are inconsistent with the Constitution. And the Constitution makes crystal clear in Article 34, Section 3, subsection 2, that the courts do have the authority to invalidate legislation that is inconsistent with the Constitution. I won't read it out, but it says it in 34, Section 3, subsection 2. Read it yourselves. It says in black and white, the authority of the High Court and the Court of Appeal and the Supreme Court extends to the question of the validity of laws under the Constitution, basically. So there's an explicit express authorization for the High Court to strike down or invalidate unconstitutional laws. There is no equivalent in respect of the executive. That's the point I'm trying to make at the outset here. There's no explicit provision in the text of the Constitution that says the courts can invalidate acts of the government that are inconsistent with the Constitution. Now, it's pretty clear by implication that the courts have that authority. Let me jump forward to the piece of text up here. Article 28, Section 2. It looks really simple. We'll just read it for a second for yourselves. So, like, you might say, well, what's the most striking phrase in it? And in this context, I think the most striking phrase is subject to the provisions of the Constitution. So the executive power of the state shall be exercised by the government. I mean, that's obvious. The executive power of the state shall be exercised by the government, but subject to the provisions of the Constitution. In other words, if the government acts, the implication is if the government does something that's unconstitutional, then they can't do that. And I suppose, who stops them? Who stops them? Well, the implication is that the courts have the authority to stop them. Now, in this topic, then, what are the big cases? Well, I would say probably the biggest case is this guy here, Elijah Burke's case. That was decided in 2023. Yeah, 2023, I think. Elijah Burke, right? So I've mentioned that case once or twice already. It's the calculated grade scheme case. He had been homeschooled by his mother. Minister for Education, in the context of COVID, introduces this scheme exercising her executive authority. In fact, she said in her statement on the Department of Education website or whatever, what I'm doing here is in the context of my authority under Article 28(4) of the Constitution, or 28(2) of the Constitution, is exercising the executive power of the state. And there was a reason she did that. Her lawyers told her to do that for reasons which we'll get to. All right. But this was Norma Foley 3 or 4 years ago. And she said, I'm setting up this calculated grade scheme, right? Because we can't have the leaving cert because of this COVID pandemic. And here's the scheme. And obviously, it's a very complicated scheme, you know. And if your auntie is your French teacher, well, here's the situation. Here's the workaround. She can't be giving you the calculated grade because she's going to give you an A, of course. Do you know what I mean? So here's how we work it. But, you know, there's 60 or 70,000 leaving cert students, but there's probably a couple of hundred or maybe a couple of dozen people like Elijah Burke who were homeschooled. In other words, they've never been to school. They were homeschooled. And in his case, he had been homeschooled by his mother. So who was going to give him a calculated grade? So the minister said, look, basically, I'm paraphrasing, of course. So the minister says, well, God damn, I'm busy. There's a pandemic on. I can't find a workaround for you. You're going to have to wait for a year, mate, and do your leaving cert next year. And he said, well, hold a second now. I've got rights under the Constitution, under Article 42. If you look at 42, you'll see loads of stuff that supports this idea that my parents have a right to homeschool me. And, you know, I've got a right to be homeschooled, and yet I'm losing out here on something really important. Anyway, judicial review of executive power. And the reason it's a big case, frankly, is because Donald O'Donnell, the Chief Justice, really shed a lot of light on all the cases that had come before and kind of said, look, here's what the position is in Irish constitutional law. And the big cases that came before were, I would say, these ones. Boland and the Taoiseach, you see up here. Now that's an interesting case. We're going to talk about that today in a few minutes. Okay, we'll probably push on till hour, guys. McKenna and the Taoiseach. This is Kevin Boland and the Taoiseach, right? McKenna and the Taoiseach. Patricia McKenna, former Green Party MEP. Kevin Boland was a former Fianna Fáil minister. McKenna and the Taoiseach, 1995. TD and the Minister for Education, we know already about that, obviously. Oh yeah, this is the big beast over here. Crotty and the Taoiseach, 1987. Ray Crotty, Trinity College academic, who took a case against the government, against the Taoiseach in 1987, arguing that the government, Gareth Fitzgerald's government at the time, did not have the authority, the constitutional authority, to ratify a European treaty, the first substantial amendment to the Treaty of Rome. So obviously afterwards we got treaties that you might have remembered, that you might know the name of, like the Lisbon Treaty, obviously the Nice Treaty, the Maastricht Treaty, etc. This was the so-called Single European Act, which was obviously in the mid-1980s, late 1980s, and it was the first significant evolution, let's say, of what we nowadays call the EU. And Ray Crotty said, hold a second now, you know, you guys are ceding more of our authority, of our sovereignty rather, and you can't do that. You don't have the authority to do that. So he went to the High Court and challenged the authority of that government to do what it was proposing to do, and he won. But I suppose from our perspective, it's really important for this question of judicial review of executive power. And somebody asked me the question, just at the tail end of the last topic, the socioeconomic rights topic. You know, do the government ever hand down mandatory orders? Well, this is a case where they did. They said, no, mate, you can't do that. Well, no, to the Taoiseach or the government, you can't do that. You have to have another referendum. So Crotty was a big case. And then Pringle is kind of like Crotty Mark II, and then Elijah Burke. So they're the big cases. And as I said, these are the very significant cases, Crotty, Elijah Burke, and TD. And this is the really big one, Elijah Burke. Okay, fine. But guys, you know, in this topic, you already know, obviously, a good few of the provisions of the Constitution that are important. But I would say here that you really need to know intimately, really, Article 29 in particular of the Constitution and what it says. Article 29. Because we already know Article 6 very well. It's always good to have another little look at it, because it's, in a sense, it's the foundation article here for this topic, because it's the separation of powers. But it says something so simple and so familiar to us at this stage. Okay, so that's Article 6. And Article 28, we already know. We already looked at it just a few moments ago, and we saw that phrase there in the middle okay, that implies that the executive can be stopped sometimes, perhaps, subject to the provisions of this constitution. But now we get into new stuff, new provisions that you haven't seen before. So I just draw your attention. I'm going to go through these slowly, if you don't mind, rather than rushing through them, because what we're trying to get here now is a picture in our heads of the constitutional infrastructure with respect to foreign policy, that particular domain of foreign policy. Who gets to govern Ireland in respect of its foreign policy? Of course, you know the answer intuitively already. The executive power of the state in or in connection with its external relations shall, in accordance with Article 28, be exercised by or on the authority of government. The new Minister for Foreign Affairs, as of yesterday, is Simon Harris, right? So he's in charge of foreign policy. Now, of course, the government as a whole is in charge of foreign policy, or responsible or answerable for foreign policy. But Harris is on top of the tree, of that particular tree, if you like. He runs the Department of Foreign Affairs, and there's a whole infrastructure beneath him, as it were, Department of Foreign Affairs, diplomats all around the world, etc. Ultimately, they're all answerable to Simon Harris now for the next 5 years. And Simon Harris, ultimately, well, think about it. Who is he answerable to? Well, what does the Constitution say he's answerable to in respect of how well or how badly he does that job, or for what he does and for what he fails to do, if you like? Basically the Dáil. The Dáil holds him to account day by day, week by week, month by month. Fine. That's what the Constitution kind of envisages. Is Simon Harris answerable to the judges in the High Court? For how he does, or what he does, and for what he fails to do? What does the Constitution suggest to us about that, do you think? Well, fine. So look at Article 29.4, Article 29 generally, I should say, and kind of have a sense. And it's an interesting article, because what I would say to you when you read it, I'll just go through them in a second, but it shows us that this Constitution was drafted very intelligently, was drafted very carefully and thoughtfully, and that each little piece of the jigsaw fits in neatly and answers to other pieces of the jigsaw in other parts of the Constitution. So just take a look for a second. Now, this is really, really wordy, 29.4.2, but I'll summarize it for you. It says that as part of that authority, the government has authority to ratify treaties that will bind the state in international law. So it's very, very verbose, but basically it says that. So let's have a quick scan of it. For the purpose of the exercise of any executive function of the state in connection with its external relations. I should say, incidentally, sorry to interrupt your train of thought there as you read that, but Article 29 has a heading on it, international relations. Article 29 is about international relations. Basically, it says, in summary, the executive is in charge of international relations, but it's not unaccountable. For the purpose of the exercise of any executive function of the state in connection with its foreign policy, the government may, to such extent and subject to such conditions, if any, as may be determined by law, avail of or adopt any organ, instrument, or method of procedure used or adopted for that purpose by members of any group or league of nations with which the state is or becomes associated, for the purpose of international cooperation in matters of common concern. So you might say a few things. You might say, well, it envisages that the Constitution envisages that the state is going to cooperate with other states. And that, that might mean, bind itself by treaties in international law, whereby it can't do some stuff that it might otherwise want to do, because the government who's in charge of foreign policy thinks that that's in the interest of the country. 29.4.2. 29.5.1. Every international agreement to which the state becomes a party shall be laid before Dáil Éireann. So the government is answerable to the Dáil for what it does and fails to do. 29.5.2. The state shall not be bound by any international agreement involving a charge upon public funds unless the terms of the agreement shall have been approved by Dáil Éireann. Now, that also makes sense, and it fits in with Article 17, for example, in the sense that, the Constitution says ultimately that the Dáil is in charge of public finances. Do you know, the Public Accounts Committee, for example, like the Dáil has to pass a budget. Like if the government wants to pass a budget and doesn't get, if the government proposes a certain budget and the Dáil doesn't approve it, it doesn't get enacted into law. The Dáil is in charge of the public purse, and 29 Section 5 kind of acknowledges that. And no international agreement shall be part of the domestic law of the state, save as may be determined by the Oireachtas. That also chimes with Article 15(2)(1), which is a provision of the Constitution that I come back to nearly in every class. You think about it for a second, guys. You know the provision so well at this stage. Like I'm forgetting the start of it right now, but the sole and exclusive authority to make laws for the state, the sole and exclusive authority to make laws for the state is vested in the Oireachtas, not in the Dáil, in the Oireachtas. That is to say, the Dáil and the Seanad. No, the sole and exclusive authority to make laws for the state. But you remember, bear in mind, guys, I'm sure you'd have thought about this over the last few months, but you wouldn't have been confident enough to say it, that most of the laws that we're subject to aren't made by the Oireachtas, or at least many of them, and probably most of them. Most of the laws come from European institutions, the European Union. You say, well, hold a second. The Constitution says the sole and exclusive authority to make laws for this state is vested in the Oireachtas. No international agreement shall be part of the domestic law of the state. So now that's anticipating or envisaging a distinction between international law on the one hand and domestic law on the other. International law and domestic law. Right. Just wanted to kind of share one or two other provisions from 29 with you. I can see some of you are already looking at them, and that's great. Article 29, Section 1. I'm reading this now from my own constitution here in front of me. Ireland affirms its devotion to the ideal of peace and friendly cooperation amongst nations, founded on international justice and morality. 29.2. Ireland affirms its adherence to the principle of the pacific settlement, the peaceful settlement of international disputes by international arbitration or judicial determination. 29.3. Ireland accepts the generally recognized principles of international law as its rule of conduct in its relations with other states. And then we're on to Article 29.4, which is this one here. And then, of course, there's another really important provision in Article 29, which we will get to next week. And that's the provision that makes it okay for EU law to be binding in domestic Irish law and makes it consistent with 15(2)(1). So we'll get to that next week. But just before I leave you guys, I'm sorry I can't just leave you just there, because I want to try and stay in sync with the other crowd, and last time we got to the point where we were discussing this Kevin Boland case. So this is from 1974. And Kevin Boland had been a member of the Fianna Fáil government. I guess that government had been voted out of office. My dates are a bit, I didn't check this, and I should have, but Fine Gael must have won power. Fine Gael, I think, won power in the early 70s. So Boland must be no longer in government. And in fact, I think he fell out with Fianna Fáil and left Fianna Fáil and joined a political organisation that since, I presume it's defunct now at this stage, but later became a kind of a far-right movement or organisation in the 70s. And, was very, for want of a better word, very, very Republican in orientation. So Boland had been on the, let's call it the Republican wing. That's a very misused or abused phrase in my view, but let's call it the Republican wing of Fianna Fáil. And the Troubles, of course, had broken out in Northern Ireland. The Troubles had broken out in Northern Ireland in the late 60s, I guess 68, 69, 70. And in 74, the government of Ireland, which at that time, I'm pretty sure, I think Gareth Fitzgerald was the Minister for Foreign Affairs, but I'm not certain, was a Fine Gael-led government, but they reached an agreement with the British government at the time called the Sunningdale Agreement. And the Sunningdale Agreement was a little bit like the Good Friday Agreement. The basic principles of it were the principles that were established later in the Good Friday Agreement. In fact, in 1999, the Good Friday Agreement is ratified in 1998. The Good Friday Agreement, and at the heart of it, of course, is the principle of consent, which is a very, very radical principle, which says basically that the fate of Northern Ireland should be decided by the people of Northern Ireland. That the fate of Northern Ireland, its constitutional future, should be decided by the people there, by a majority of the people living there. Now, that is the basic principle. And that had been agreed to by the British and Irish governments way back in 1974 at the very start of the Troubles, before everything that happened, or not before, but, you know, the Troubles went on for another, what, 20 years? 25 years. And they reached a conclusion that they had already had at the start, I would say. So Clause 5 of the Sunningdale, so Seamus Mallon, the SDLP politician, famously described the Good Friday Agreement as Sunningdale for slow learners, you know. And Clause 5 of the Sunningdale said the Irish government fully accepts and solemnly declares that there can be no change in the status of Northern Ireland until a majority of the people of Northern Ireland desires a change in that status. And Kevin Boland didn't like that. And he went to the High Court, or he got his lawyers, Sean McBride, also a Republican, to go to the High Court and argue that the Irish government did not have constitutional authority to sign that agreement, to sign Ireland up to the Sunningdale Agreement. And specifically, his argument was that that Clause 5 clashed with or was inconsistent with the terms of Article 2 and 3 of the Constitution as they then stood. Now, we haven't mentioned Articles 2 and 3 of the Irish Constitution yet this year in our class. And they changed, of course, by referendum in 1998, 1999. After the Good Friday Agreement, they changed radically. But at the time, or from 1937 all the way until 1998, this is what they said. Article 2, the national territory consists of the whole island of Ireland. Article 3, pending the reintegration of the national territory, and without prejudice to the right of the Parliament and government established by this Constitution to exercise jurisdiction over the whole territory, the laws enacted by the Parliament shall have the like area and extent of application as the laws of Ser Stat Éireann, and the like extraterritorial effect. In other words, what Article 3 did was, the old Article 3 that is, it made a claim to the whole territory, and specifically made a claim that the Parliament and government established by the 1937 Constitution had a right to exercise jurisdiction over the whole territory. Of course, what it also did was recognize the reality that it couldn't. So it said, without prejudice to that right, the laws enacted by the Parliament shall only have effect in the 26 counties. But Kevin Boland went to the High Court, or Sean McBride, his senior counsel, went to the High Court and said, look, Judge, Clause 5 of the Sunningdale Agreement flatly contradicts Articles 2 and 3 of the Irish Constitution. And Article 28.4, Article 28.2, I should say, of the Constitution says that the executive power of the state shall be exercised by or on the authority of government. And 29.4.2 says that the state can sign, that the government can sign Ireland up to various treaties and agreements in international law. But 28.2 says, subject to the provisions of the Constitution, can't do stuff that's inconsistent with the Constitution. And this is inconsistent with the Constitution, because it's in plain and obvious violation of Articles 2 and 3. And that goes to the High Court. And, you know, Boland is interesting for this reason, I suppose, that before Boland was decided in 1974. Before Boland, I don't think people had kind of realized that there was no explicit provision in the Constitution to say that the judges had authority to block government from doing stuff when government was exercising its executive power. So this kind of prompted them to kind of think about that. And essentially, probably largely because of that lack of a textual authorization, the High Court said, well, look, we can't really stop this. Show us, they said to the lawyers, show us what provision of the Constitution authorizes us to stop this. This is the government exercising its executive power in the domain of foreign policy. This is the government's business. And we don't have any power to stop them. But what the judge, Chief Justice Fitzgerald, and just bear with me on this because I'll leave you now in about 3 minutes. Chief Justice Fitzgerald innocuously, kind of casually, made this statement in the course of his 10 or 12-page judgment in the case. And just read the wording of it. In my opinion, the courts have no power, either express or implied, to supervise or intervene with the exercise by the government of its executive functions, unless the circumstances are such as to amount to a clear disregard by the government of the powers and duties conferred upon it by the Constitution. Now, it turned out, I don't think Fitzgerald intended this, but that turned out to be very significant, that line, because it's pitched as a very kind of a modest line. It's pitched as to say, like, we've no power here. We, the judges, have no authority here. It's pitched as a negative, but it turns out to have the opposite effect, because the implication clearly is, well, if the government acts in a way that would amount to clear disregard of the Constitution, then we've got authority to intervene. So it establishes what has since become known as the clear disregard test. Now, funny enough, thinking about it and just talking about it out loud with you guys, you might say, well, Clause 5 of the Sunningdale Agreement is clearly at odds with Articles 2 and 3 as they then stood. It's in clear disregard. You could say that. And what does clear disregard mean? Well, I suppose it's not a scientific, like, that's the problem with law or constitutional law. It's the nature of it. Like, it's not a scientific mathematical test. You can't spill the thing into this cup and see does it turn orange. What is clear? What does amount to clear disregard? Well, I guess, guys, I would say that to be honest, I read Boland the Taoiseach the other day in preparation for this class, and I was struck by how not poorly reasoned it was, but how what's the word for not comprehensive? I mean, I was kind of saying to myself, is it even worth putting that up on loop for the students? It's a really short judgment, and there's no real reasoning, And basically, my impression is that the court said, "Oh God, we can't do that. We can't do that. This is the government just conducting foreign policy, reaching an agreement with the British government, doing stuff that's its business. We're not going to stop them from doing that." And then he comes out with this innocuous line, but it ends up setting a threshold. Do you remember I talked about the different thresholds for the different? So it ends up establishing a new threshold, which is seen as a really high threshold. In other words, we're not going to stop the government if the government is doing stuff that's arguably inconsistent with the Constitution. But if the government does something that's in really, really clear and obvious breach or egregious breach, then we could stop. Then we could step in. So now we're seeing some separation of powers. We're seeing a little bit more flesh on the bones of it, if you like. And the clear disregard test becomes a big deal later on. And it comes into play very much in Elijah Burke. And also in Crotty and the Taoiseach. Guys, thank you so much to Cian, Firdaus, and others who turned on their screens. Thank you very much to everybody else for being here. And I look forward to seeing you on Friday next in person. All the best.